Have you ever been asked by a bank or an insurance company to provide letters testamentary and wondered, what are they and how do I get them? If so, then this informational video is just for you. Letters testamentary authorize the executor, that is, the person named in the will, to act and conduct business on behalf of the estate. And that's important. So today I want to share with you 3 tips that you should consider as you obtain the letters testamentary that you need. Wouldn't it be nice if someone handed you a list of everything that you need to know about the probate process and how to obtain your letters testamentary? I get it. We both know that the probate process can be complicated. And the law governing probate in Texas that's found in the Texas Estates Code seems to be changing all of the time. One may ask, how am I supposed to know where to start? How will I know if I'm making the right decision? Well, if you focus on the tips that I share with you today, you'll be well on your way to understanding how to obtain the letters testamentary that you need. And that's good news. The more informed you are, the better choices you will make. Are you ready? Hi, I'm Jim Soto with the Soto Law Firm, a probate, guardianship, and estate planning law firm located in Houston and serving clients throughout Texas. You don't have to go through the legal process alone. My 25 years of experience will serve as your guide when you need it the most. Now, so let's put together a short checklist of 3 tips that you should consider to obtain the letters testamentary that you need. While creating this checklist, let's consider, first, make sure that the will is valid. If the will is not valid, it won't be accepted by the court, and you won't receive the letters testamentary. Second, file the application to probate the will in the appropriate court. Not all courts handle probate matters, so you need to be in the right court. Third item on the list, go to court and have your case heard by the judge. At the hearing, the court will consider all of the evidence in your case. If everything is in order, the judge will appoint you as executor, and then you sign your oath and request the letters testamentary that you need. On top of these tips today, at the end of today's video, I'll provide you with a link where you can obtain a free consultation to ask any questions that you may have. So you ready? Let's get started. Let's talk about this in more detail. Step number 1, determine if the will is valid. At a minimum, a will in Texas is valid if 1 is in writing, 2, it is signed by the testator, that is the person making the will, or by another person at the testator's direction and in the presence of the testator, and 3, if the will is attested to by 2 credible witnesses. You should consult with your attorney of your choice to determine if your will meets the requirements to be a valid will under Texas law. But wait, what if I don't have a will? For cases where someone dies without a will, then you go down another path. That is, you will follow the rules of intestacy and obtain letters of administration. Letters testamentary if you have a will, letters of administration if you do not have a will. Step 2. After you've determined that the will is valid, you are ready to file the application for probate requesting letters testamentary in the appropriate court. But wait, what happens if the executor named in the will is dead? Here's a tip. Texas law allows the beneficiaries named in the will to collectively designate someone to serve as independent administrator of the estate. That is, the beneficiaries can get together and decide who will be in charge. In that situation, you will receive letters of administration with will annexed. But don't worry, these letters of administration give you the complete authority to act on behalf of the estate. Step 3. So if everything is in order, then the application to probate that will and requesting letters testamentary is ready to be filed in the court with the appropriate jurisdiction. Meaning that if your county has a probate court, then you file in the probate court. For counties that do not have a probate court, you file in the court with probate jurisdiction. Consult with your lawyer to find out where your will needs to be filed. Tip: the original will must be filed with a probate clerk's office within 3 days of filing the application for probate. Ensure that this is done timely. The next step on our checklist is to set a hearing and get before the judge. At the hearing, the judge will hear all of the evidence, determine if the will submitted should be approved for probate. If so, the judge will sign the order admitting the will to probate and for issuance of letters testamentary that you need. Now that you have the letters testamentary or your letters of administration, there is much more that needs to be done to administer the estate. Consult with your lawyer to see what needs to be done next. So there you have it. Those are 3 tips that you can use to obtain the letters testamentary that you need. Let's recap. First, we talked about determining whether the will is valid. Then, we talked about filing the application in the appropriate court. And then we talked about getting your case before the judge. Remember, your goal is to get the letters testamentary that you need. So follow through with these steps and you may be well on your way of obtaining your letters testamentary. To get you started, I've provided you with a free legal consultation to ask any questions that you may have. So make sure you go over to my website and schedule your free consultation. I will include a link at the end of this video. Remember, you don't have to go through the legal process alone. Step by step, I will serve as your guide. Call me. I look forward to meeting you.